Good afternoon and welcome to our second webinar in Tennessee's virtual pretrial symposium series. It is great to see some familiar faces from our first webinar on Tuesday. For those of you joining us for the first time, my name is Jeremiah Morton and I'm the Assistant Director of the Office of Criminal Justice Programs. OCJP is excited to be hosting this series in partnership with the Crime and Justice Institute to talk about how we can improve pretrial systems throughout Tennessee. During the first webinar, we heard how Hamilton and Madison counties started pretrial projects in their counties with funding from OCJP. Director Brinkman with our office also talked about OCJP's commitment to pretrial justice and the funding opportunities available for counties interested in improving their pretrial system. These grants are for $50,000 in funding for jurisdictions interested in implementing pretrial initiatives, and that link should be posted at this time. If you missed the live webinar, you can catch up with the recorded version when it is posted to the event website. You can also watch recorded interviews with national pretrial experts on the website and learn a little more about our featured speakers and panelists. The link is on your screen and also posted in the questions tab. These videos features Judge Ronald Adrien, who recently retired from a 36-year career serving on the branch of Cleveland, and NAPSA's President-elect Spurgeon Kennedy, who had over 50 years working experience as a pretrial services practitioner, training, and technical assistance provider. The speakers are experts in their fields, and I highly encourage you to watch the videos. The interviews are only about 30 minutes each and well worth your time. On Tuesday, we talked about the motivation for pretrial reform and how to get started. Today, we will focus on identifying challenges that face pretrial systems and finding effective solutions to those challenges. During this webinar, Tara Blair, the Executive Officer of the Kentucky Pretrial Services Department, will tell us how Kentucky was able to create an effective statewide pretrial services agency. She will explain the challenges they faced along the way and how they overcame those challenges. We will also share a resource that will help you identify some challenges facing your jurisdiction and take the first steps to implementing solutions, potentially with OCJP funding and the grants that I've already described. Thanks again for being with us, and let's get started.
Thanks, Jeremiah. I am very excited to introduce all of you to our speaker for today. As I mentioned earlier, my name is Jessica. I'm the pretrial manager at the Crime and Justice Institute, or CJI. For those of you who don't know who we are, CJI provides criminal and juvenile justice training and technical assistance nationwide and is partnering with OCJP to facilitate this pretrial series. Our speaker today is Tara Blair. She is the Executive Officer of Kentucky Pretrial Services, and she's worked in the Pretrial Services Department since 1995. And she's here to talk with us about the process Kentucky went through to implement changes to the state's pretrial system, what worked well, lessons learned along the way, and where Kentucky is now. Kentucky continues to be a national leader in pretrial, and we hope that hearing their story will be both informative and inspiring to those of you who want to make improvements in your own systems. During her time with Kentucky Pretrial Services, Tara gained extensive experience developing, implementing, and improving almost all aspects of the pretrial program, such as mission, goals, and objectives, pretrial risk assessment and data management, policies and procedures, pretrial training for staff and other system stakeholders, case management systems, reporting, quality assurance protocols, and performance and outcome measures. In addition to all her work in Kentucky, Tara works as a consultant providing program assessments, training, and technical assistance nationally and internationally. I have a few questions for Tara that I want to cover, but then we will have a few minutes at the end for your questions. So to ask a question, please use that questions tab, and then I'll read those questions out loud during the Q&A. So without further ado, let's get started. Welcome, Tara. Thank you so much for being here.
Hi, thank you. It's a pleasure to be here.
So Kentucky has really paved the way for national pretrial reform since the 1970s. Before we dive into the questions I have for you, can you just give us a few of the highlights of how pretrial reform started in Kentucky and how it has evolved over the past couple of decades?
Absolutely. Kentucky pretrial started in 1976. So we've been going at this for 44 years. I personally was not working in 1976 because I was a child, but I was very fortunate to be able to, when I started my career in 1995, a lot of what we call the founders, the founding fathers and mothers, were still working. So I was very privileged to be able to work under some of these people that had actually paved the way and were literally there, boots on the ground. I also had the opportunity to do an interview it's probably been about 8 or 9 years ago, of our former governor, Julian Carroll, who was the one responsible for initiating pretrial services and enacting the laws that made us be. So I do have the historical perspective prior to my tenure in 1995. But basically, prior to 1976, we had commercial bail bonding for profit, as I believe Tennessee does today. And former Senator Julian Carroll was a state representative at the time, and he was also a lawyer. And at the time, that business here in the state was very corrupt, and there were a lot of issues. And he had a personal mission to regulate the bail bondsmen, and then that soon turned into eliminating them. So it was basically in the beginning one man's quest, because he saw what was happening to his clients that when he was a lawyer. So in 1976, Kentucky passed the Bail Bond Reform Act. That created pretrial services and placed us under the Supreme Court and soon to be the Administrative Office of the Courts, which went into effect in 1978. So that's how we started. And in Kentucky fashion, the people that were working back then, literally, and I say this is a true story, they had 30 days to create a statewide pretrial program. From the time that the law passed to implementation, they had 30 days. So they could tell me stories about, we didn't have computers back then, none of that stuff worked. So it was, and we still make change like that today. But that's basically how we started. Then through the years, as time passed, at the beginning, it was more of just changing the culture of having this new agency. And then as time passed, each year the legislator would give us more and more duties. Because we were the first contact with the court system, that was the ideal place for us to be the bridge between the jail and the court. So as years passed, they continued to give us more and more duties. But unfortunately, we got a little complacent and kind of stale. So from probably the late 80s until the mid 90s, when I started, we had zero change. So we started seeing issues with our jail population increasing. We didn't have pretrial supervision back then, so there was some issues. Even though we had this great system, we still had some issues. So along the way, we made more reforms. Some of them were self-initiated. When I say self, meaning agency initiated, such as adopting a risk assessment, beginning to do pretrial supervision, internal quality assurance measures, things like that. And then there's also legislation that was passed in 2011 that sort of mandated the things that we were already doing, like risk assessment, supervision, and things like that. And then going forward, we continue again to look at everything that we do to try to better what we're doing, to provide services to defendants in the courts and all of those that we serve. So that's kind of like the highlights of our 44-year journey. So I'll go ahead and turn it back to you, Jesse, to see what you want me to talk about next.
Yeah, that's hard to wrap up that amount of time in just a few minutes, but thank you. Thank you for that overview. And you told us a little bit about the catalyst for how pretrial reforms started, but what kept you motivated over those years to try to reevaluate and keep reform going?
I think the underlying motivation for any type of change or reform or any agency, ours was justice, equality, and the presumption of innocence. I mean, that is the driver. Our agency was created so that defendants didn't languish in jail. And we truly believe as an agency in pretrial justice, equality, and fairness, and that's the motivator for every reform that we do, is to make sure that people are treated fairly and that we uphold that presumption of innocence. So that's pretty much the main mission, I guess, and motivation behind this is, again, just justice, pretrial justice.
And with that said, what does pretrial services look like now in Kentucky?
Well, we look a lot different than we did in 76. In 76, we had 80 employees statewide. Today, we have 277 employees that we divide up into regions. And as I said before, Kentucky is a unified court system. So our pretrial department is housed in the statewide administrative office of the courts. And I'm not sure if Tennessee has local courts or municipal courts, but we don't. All of our courts are state courts. So they're state court judges, and the pretrial officers are state employees that actually work for the administrative office of the court. So I'm based in our capital city of Frankfort. So all the employees are under the Frankfort office. So they do not work for the local judge. They're not county employees. So that I wanted to, and we've never been county employees. What's unique is our jails are county funded. So we're state employees. So every person that we get out of the jail safely is one person that the county doesn't have to pay for, but the county doesn't pay for pretrial. So that's why we're a little bit unique, because we are state. But anyway, we have 277 employees. We do investigation, which includes an interview. We do a risk assessment. We also have monitoring. We have supervision and diversion. And how we operate, just to give you an idea of the process, when someone's arrested, of course, law enforcement brings the defendant into a county jail, and we have 24/7 coverage statewide. And the way we're able to do that is we do it remotely. Being a state agency, we have, as you all know, like Tennessee, we have Louisville, we have Lexington, we have Northern Kentucky, and then the rest of the state is pretty much rural. So you all have got your Nashville, your Memphis, your Knoxville. So, in these smaller counties, they don't have the arrest caseloads as the larger cities. So we don't have physical staff that works the jail in every county. So during the day, we have staff assigned to offices, but when someone's arrested, we have what we call a hub, which is employees that are 24/7. They're spread out through the state. So the jails scan and email the citations into what we call pretrial citations. Then the pretrial officers that are on duty make contact with those jails. They enter the stuff into our system, and then they determine if someone's going to be AR eligible, which I'll talk about that here in a minute. We do a phone interview with the defendant. Now, I have to back up, because pre-COVID, we were doing phone interviews in about half of our jails. So about 40 of the 80 jails, and we were physically going to the other jails. Well, once COVID hit, now we are not doing any in-person interviews. They're all over the phone. So moving forward, that's probably the model that we'll keep, but I just wanted to throw that out there. So again, we're processing defendants, we're doing phone interviews with them. Then that information that we put into our system goes into a queue. So we have other staff who we call risk assessment specialists. These are highly trained individuals that are doing just the risk assessment. And I don't know how many of you all use, the thing with not having live events is I can't see the audience. So I don't see the head nods. I don't know how many of you all have a risk assessment, how many don't, but those of you that do, you know that it's not really simplistic. You're having to go through complicated criminal history information, oftentimes from other states. So it's very complicated information. So we have designated staff that just do the risk assessment. So while they're doing that risk assessment, the pretrial officer's doing the interview. And then at the end of that, we decide, is the person able to be released immediately? And that's what we call administrative release, which does not include a judge. Or do we need to present that to the judge within 12 hours? So that's kind of like the process on where we are now. What's different from now than 76 is we do everything remotely, and we actually have computers and ways to do that more efficiently. Okay. Oh, sorry about that. I didn't mean to push that through.
Oh, you're good. And thank you for explaining all that. And I wonder, could you just maybe expand a little bit more on the supervision options you have and the diversion options?
Absolutely. If a person is released on administrative release, that's just a straight recognizance release, an ROR. And the only conditions that we place on those defendants is make all your court appearances and do not violate any local, state, or federal laws. So those are the people we're pretty much releasing, and we do text reminders on everyone. So they're getting a text court reminder. And again, that's everybody. It doesn't matter if they're under pretrial supervision, if they're released by us, or if they post a money bond. Everybody that comes through us that gives us a text number and gives us permission, we're doing a text court reminder. So that's sort of our lowest level of just monitoring. If we present a defendant to a judge, then a judge has various options that he or she can utilize. They can, of course, they can do recognizance, they can do what's called an unsecured bond, they can do a third-party signature bond where another individual signs somebody out, or they can set a money bond that the defendant can post. They can also, the judge can also set any range of conditions that he or she feels necessary to ensure court appearance or public safety. So some judges will do, of course, no contact. If there's an alleged victim, there's going to be a condition of no contact. There's also, if they want them to be monitored by pretrial services to be or supervised by us, then they can send them for that. And that's what we do there is we do check-ins. We used to do them in person, but now we do them all by phone, of course, which probably, given what we're seeing, is probably going to be our model going forward as well. But telephone check-ins to make sure that the defendant is updating their address and their phone number. And the importance of that is so that we can get notice of court dates. So not only the text reminders, but if a court changes or reschedules a court date, then the clerks would send them a court notice. So we need to make sure we have updated address. So that's really important there. Some other options that a judge could do is they could refer a defendant for an assessment to see if there's any mental health or substance abuse issues. And based on that, the defendant can be referred to services. And we sort of coordinate that if there's any referral to services in the community. Some judges use drug testing. I'm not a big fan of drug testing without the treatment component, but again, some judges do order drug testing. And if they do that, then we do monitor that. We do not have the resources or the budget to pay for that. So unfortunately, that is a condition that ultimately ends up, even though the release from jail didn't require money, it does require a defendant to pay for that drug test. So that kind of is a financial condition. Other options the judge has is they could place them, say that you can't leave a certain place. They can require them to stay at a certain place. Electronic monitoring, that's always a question that people from other places ask me. We don't supervise that. In Kentucky, pretrial doesn't. Our jails have programs. So if there's an ankle monitor, then that would go through the jails. Or if a county that a jail doesn't run it, then the counties would have contracts with providers to do that. And the main reason why we don't do that is, we're not sworn law enforcement. So if someone was to cut it off or do something like that, all we could do is contact a judge. So it just works better to have the jails monitor that. So that's it. Again, pretty much all of the different options. And one thing in Kentucky that, and I guess, it's okay to get into this early, Jessica, but one of the things that I think, not really a challenge, but one of the things that, would we do differently? Years ago in like 2005, we jumped into this pretrial supervision head first and said, hey, we can do this and we can do that. And what we found is we did a lot of over supervising. So people that really just needed that court reminder ended up having all of these conditions, and we were setting people up to fail. So that's another thing through our reform efforts is we've scaled back, our level of supervision and the amount of defendants that we supervise, so that we can save those resources for the people that really need it. So that's one thing I would caution you, if you're going to go down the supervision road, that you make sure you don't overutilize supervision, especially on people that are lower risk, lower charge, that don't really need that extra level of supervision.
And that's actually a great lead in to my next question, which is, do you have a good way of determining what's working well and what might need to be adjusted as you go?
Yes, I actually have some data to share with you on an experiment that we did, or a study that we did. We started looking at we always look at our data, of course, but I noticed that it seemed, according to our release rates, that they were declining. So it looks like, if you see on the slide, in calendar year 13, we had a 74% release rate that dropped down to 67, 65. And I'm looking at this and I'm like, there's something wrong here, because it seems like people are getting out of jail. Well, what we found is, and I don't think Tennessee operates this way. I'm pretty sure that it's just us in Louisiana, but our county jails are also used to house convicted state felons serving a sentence of up to 5 years. They're kind of like mini prisons, and the state reimburses the jail. So we spend a lot of time in pretrial dealing with just where people are, and they have multiple things going on. They could be serving a sentence and have a pretrial matter. So with that going on, I was like, okay, we need to do a snapshot and we need to look and see who's in our jail and why are they there, because our release rates seem to be dropping and we need to figure out why. So we did a study, and then it was manual process. Whoops. So this was a manual process back then, and what we found was that 32% of the people that were in jail that appeared to be in their pretrial, meaning they had at least one open pending case, had a holder. So that's a lot. So that explains why our release rates were dropping. It wasn't that less people were getting out of jail, it's that people had other things preventing them from getting out of jail. So again, 10,000 defendants, but 32% of them had a holder, which really we only had 6,700 that were held slowly on a pretrial matter. So again, this is just a way that we look at our data to sort of see what's going on and try to make changes. So what we found also was, oh, sorry, let me back up. So now today, based on that manual, now every day we have what's called a daily snapshot. So now we don't have to do it manually. So every day we see how many people came in the day before, what were the outcomes, how quickly did they get released. So this here means they got released within 12 hours. So some of the things on here you'll see, like, you know, non-financial custody, that just means they were authorized in ROR, but they didn't get out within 12 hours. They may have gotten out in 13. So it doesn't mean they didn't get out. So that's just another way that we try to change our processes and our policies to sort of change things and make things better. Whoops, let me back up. So another thing also I want to throw on that is another big issue, and I would suspect that this is a problem in Tennessee because it's a problem in every state and jurisdiction that I go into, are the probation violations, where people get arrested on a new charge that's pretrial and then they have a probation violation hold that doesn't get taken care of. So by us knowing who's in our jail, then we're able to work with the probation department to sort of get these, and work with the judges to get these non-pretrial matters expedited so that the person can be released. So that's another way that we just continue to change and change the things that we do.
That's great, and data is so important, right? So can you give us an example of an initiative, a policy, or practice that's working particularly well in Kentucky and why you think it's been so successful?
Well, I think that what I'm getting ready to talk about is working very well, but I guess it depends on who you ask, because we do have some critics of this program. But we started what we call administrative release, which is otherly known as delegated release, meaning release without a judge. We started a pilot program back in 2013. We started with 10 counties, expanded to 20, and then our Supreme Court, based on the results of that pilot program, then made it a statewide by court rule, by Supreme Court rule, which in Kentucky is essentially law, that all defendants charged with nonviolent, non-sexual misdemeanors who do not score high risk on our new criminal activity risk assessment would be eligible for expedited immediate recognizance release by pretrial, meaning we did not have to contact a judge. Because here, when someone's arrested, we call the judge on the phone. That's our initial presentation for bail. And then if the judge doesn't release them, then they go to what we call jail arraignments. If they get released, they go to court on their own. So this was just an expedited way. And what our pilot program showed us is that we weren't releasing people that the judges weren't. We were just releasing the ones that the judges were going to release anyway. The release rate on these people when the judges were releasing was like 98%. So it wasn't like we were releasing people they weren't. It was, we were expediting it and we were doing it very quickly so that they didn't have to wait for that judge call or wait to go to court. So that was the purpose of the program. So that was in 2013. In 2017, they made it mandatory statewide. Now, here's where I want to talk about. COVID again is going to come back up, because with the COVID pandemic, the Supreme Court amended that release and expanded it to Class D felonies. In Kentucky, Class D felony is our low-level felonies that the maximum penalty if convicted is 1 to 5 years. These are things like drug possession. Pretty much every drug possession in Kentucky is a felony other than marijuana. So that's those. Shoplifting's over 500 is a felony. So your low level, again, non-violent, non-sexual felonies, it was expanded. So if you look at this chart here, and again, I did this chart to just compare the changes in the administrative release order. It was for another presentation, but I thought it would be really good to show you all so you can see the impact of just a change in policy on how that affects pretrial release. So this blue is 2018, the red is 2019, and the green is 2020. So pre-COVID, we were releasing about 10%. So 10% of the defendants that got arrested were being released through this program, this administrative release, expedited release program. If you jump up to when COVID hit, the Supreme Court expanded our administrative release on April the 15th of 2020 by including the felonies. At this time, they also included bench warrants for failure to appear, civil matters that we never before even interviewed, but civil matters then were also eligible. So our release rate jumped up, our administrative release rate was 10%, jumped up to 39%. So 39% of the people were being released administratively versus 10. Well, on June the 1st, they scaled it back, which is appropriate. I mean, and part of the reason why they included the bench warrants was because we weren't having court. So people were going to have to sit for a month. So, I mean, there was a reason why they expanded, and there's a reason why they scaled it back too. So they scaled it back on June the 1st, and they no longer, the bench warrants for failure to appear or the civil matters, but they kept the Class D felonies. So the only change really between these numbers here in 18 and 19, once we got to June 1st, was felonies. We were releasing felonies. So there's 29%. And again, these are your low-level felonies. Non-sexual, non-violence, really important that I didn't mean to do that. I thought I had some outcome information on there, but I didn't add that slide. But and what we found too so far is we're not seeing an increase in rearrest or failure to appears on the people that we're releasing. So that's in my mind why I think this was something that was successful, because we're releasing people that were going to be released anyway, but we're doing it quickly, and we're doing it within 12 hours is mandatory, but our average length of time is 3 hours. So we're able to get these people processed and get them released so that the jails don't have to dress them out, put them in general population. They can sort of keep them in the holdover to see if they're going to get out. So I think that's successful. Now, we do have some critics that don't like the program for various reasons. Some prosecutors don't like it, but again, some do. So it's really, I guess, up to whoever's looking at it. But I think it's successful because we're expediting the release of people that are going to get released anyway. And it's helpful for the jail, and so far our outcomes are the same.
Which is really, really impressive. And when you say outcomes, are you talking about failures to appear in court, new arrests? What are you measuring?
Yes, both. New arrest and court appearance.
Great, awesome. Thank you for sharing that. It sounds like it's been a great initiative, even if it was just to get you through COVID. Mainly. It's shown here how Kentucky is a leader in pretrial, and you've seen so many great outcomes, but I'm sure that there were a few bumps along the way, and you did mention a challenge earlier, but I'm wondering, can you share any lessons that you've learned over the years, and what else, if anything, you would have done differently?
I think, there's several things that I would have done differently. One of them is, is changing business practices and policies based on your budget and not on what is the right thing. So I think, through the years, and we all had the budget cuts, and we're having them now. I mean, right now we're in a hiring freeze, but I think, changing good policy because of budgetary reasons instead of trying to find a different way to do it within your budget. And I think I learned that along the way. There was a period of time between going back about 8 years ago that we were having some issues with our budget and our staffing. So we changed, I shouldn't say we, the Supreme Court, based on my recommendation. So this is on me. This is all me. Changed the 12-hour rule to 24 hours. So at that, and that was not a good change, because our whole mission again is to process defendants. We don't want people languishing in jail. So that policy change resulted in more people staying in jail longer. So that was really probably not the best. And again, you know, I have to take credit for that one as much as, and so that's me personally. I think I've learned from that is we shouldn't make decisions based on that. Sometimes you have to, I get that, but we should have been a little bit more creative. So now that the 12-hour rule is back, we're back to that, and we've had to make some changes. So that's one of the things that I think I would have done differently. Another thing is more from an agency perspective, because we're talking about data, and I think this is really important, especially as Tennessee starts to collect data and I know some of your counties have had pretrial for a while and they have good data, but you know, not having sharing your data to everybody is also sometimes a downfall. We had some research publications that came out with some of our data sets that their conclusions it was good research, don't get me wrong, it was really good research, but not understanding what the data meant resulted in conclusions that weren't really accurate. So that's another thing I think, you know, and again, because if you're applying for grants, as I noticed, you know, you're going to have to provide data. So just make sure that the people that are getting your data understand what it is and what it means, because pretrial data is very complicated, very complicated. I mean, it'd be nice if every defendant was arrested with one case and one charge, but that's not the case. They get arrested with 5 different cases from 3 different counties and 15 charges and a probation violation. So, you know, it's just knowing what all that means and knowing that it's complicated before you share it is another lesson that we learned over time. And then I think the last one, it goes back to the AR, you know, the unintended consequences. And some of the things that we were finding is if we didn't have the clause in there recently that if someone's currently out on administrative release and they haven't been to court yet and they get arrested again, they can be AR'd again and again and again. So that created a little bit of issue. So, but we noticed that and we fixed it. So again, that's kind of like when you're wrong, admit it and fix it instead of, you know, so that's really important for us. And we're very transparent here in Kentucky. You know, we share it all. And we're happy to share it with the neighbors to our south, Tennessee. So we are very transparent, but we just need to be careful and make sure that we're making the right decisions. And when we don't, we admit it and we move on.
Yeah, and improving your pretrial system is going to be an ongoing process. So with that in mind, what's next for Kentucky? Is there anything pretrial services is focused on now?
Absolutely, and the timing of this webinar is kind of goes hand in hand with this, just with what's happening in Louisville right now with our city and there and all of the social unrest and all of that. So a big initiative for us now is what we call the RED initiative, Racial and Ethnic Disparities. And this is an initiative of the Kentucky Court of Justice as a whole. So we've been working with because again, back to what I said our mission was justice, fairness, and equality. So this ties in nicely with that because we want to be fair and we want to make sure that everybody is treated equally. So the Kentucky Court of Justice about 3 years ago started this RED initiative, and every Supreme Court Justice, Court of Appeals judge, circuit judge, district judge, every pretrial employee, every juvenile services employee, every administrative office of the court's employee, and every specialty court's employee have went through implicit bias training. We have a consultant that we worked with, Pastor Edward Palmer, and we all have went through all implicit bias, cultural collision, and even a segment called Let's Talk Race. So we're really digging into our data and finding, you know, looking at what's going on in our jails, who's getting released, and looking at that through a racial lens, because one of the things that we learned was that we all look through things from our lens. You know, my lens is this white middle-aged female lens. That's what I look through everything as. So learning to be able to look through things at a different lens. So this is a new initiative for us to, again, all back to our people being treated fairly. So we looked at data from our risk assessment, because there's been recently, I don't know if you've had any segments on risk assessment, but there seems to be some talk, or conversations about risk assessment and are they biased when it comes in terms of race and ethnicity. So I wanted to look at our data. And again, my disclaimer is this is just raw numbers and data. There's not been any full-blown research on this. It's not like a peer-reviewed article or anything. These are just numbers. So again, you know, we still need to dig deeper to look in there. But what we found statewide was that, and this was from 2018 through half of 2020, that 20% of the arrests were Black defendants versus 80% white. And our population in Kentucky is not 20% Black. So that's obvious that there's some disproportionality there at the arrest stage. So we wanted to look deeper and say, okay, we know that there's disproportionality at the arrest. What's happening to these individuals? What's happening to these people? So then we looked at the release rate. So if you look at the Black defendants, 76% of Black defendants were released, 73% of white. So we found that to be sort of a positive, say, okay, we know there's disproportionality, but it appears that the release rates, you know, are overall better. But when you look at risk assessment, we have two scales, FTA and NCA, and this is basically on one's criminal history. So the question is, do Black defendants score higher than white defendants? Well, here they do slightly, 7.6 versus 7.3, but the release rate is actually higher. So again, there's disproportionality doesn't necessarily mean that that equals disparity. I'm not saying that there's not disparity, but at least in our data. But again, going forward, we singled out 4 counties because in Kentucky, we are not a diverse state. We are pretty much all white. Everybody looks like me, just about. There are 4 counties that have a slightly higher diversity population. And those are these 4 counties, and it's about 20%. Well, in these 4 counties, 42% of the arrests were Black defendants. So that obviously shows disproportionality, huge. So again, that's something that, you know, we're identifying through pretrial that we can pass that on to that entity to look at the arrest stage. But again, we looked at the outcomes, and even though Black defendants are scoring higher than white defendants, the release rate is higher. So this is kind of where our next segment is. We're really digging into this racial and ethnic disparities piece with pretrial services. So we have a lot of work to do. Even though it appears on its face that the release rates are not showing disparity, that doesn't mean that there's not. So that's where, you know, going forward, we're going to really dig down into this and get some really good peer-reviewed research done to make sure that, once again, that we're treating everybody fairly. We can't control who comes in that jail door. That the police bring people to us, we can't control that, but what we can control is how we treat people once they enter the court system. And this is one of our initiatives, and this is very important to us, and we want to make sure that we're, as a court system and as a pretrial agency, that we are treating people fairly. So our preliminary data, as you see, looks good as far as the release rates, but again, there's more to that to come. But that's pretty much our next initiative. But we're always changing, we're always looking at ways to improve. So this is just the current initiative, and this is something that will stay with us as part of our mission too, because it goes into the fairness piece.
Yeah, absolutely, and thank you, Tara, for being willing to share that with us and being open about your data. I really appreciate that. Is there anything else that you'd like to add before we take questions from our participants?
No, the only thing that I would add is that anytime you look at reform, just to know that reform really is culture change, and it doesn't happen overnight. It takes time. Collaboration with stakeholders is very, very important. We may not all agree, but we need to work together and keep that common goal of justice in the forefront. And again, culture change is what reform really is.
And that's easier said than done sometimes, right?
Yes.
I do want to open it up for questions from all of you. We have a few minutes. So if you do have a question for Tara, please type it into your questions tab and send it along, and then I'll be able to ask them out loud. And it does look like we have a few already. So the first question we have is, what is your success rate or recidivism rate for pretrial? Do you know that off the top of your head?
I do actually. I've got it hot off the press. I just got my updated data report that goes through June 30th of this year, and our our no new arrest rate is 85%. So that would mean our, I guess, rearrest rate is 15%, and our appearance rate was 73%, which sounds low, but really it's not, because that's all risk levels. So when you break it down by risk, we release a lot of high risk people that have low level charges. So if you look at by risk score, our lower risk people are coming back 92%, all the way down to our high risk, which are like 50-50. But the statewide is 73% for the appearance rate and 85% no new arrest rate.
Great, thank you. We have a few more questions coming through, so I'm just gonna read through them here. Okay. What are the benefits of having the centralized pretrial staff rather than like a county pretrial offices?
Yeah, that's a really good question, because since we've had it no other way here in Kentucky, it's hard for me to answer, but I like the centralized because you can service the entire state, including the very rural areas, equally. So it doesn't matter if you get arrested in Fulton County, Kentucky, which has like 3 arrests a week. We're going to process them within 12 hours, just like we are someone arrested in Louisville, where we have 24/7 on-site staff. So not having those county lines, we're able to pool resources. I mean, I don't know how we would afford a pretrial program in some of these small counties that have very few arrests. It would be a hard sell to have a full-time employee when you have 20 arrests a month. So again, we're able to pool resources and staff that work on a statewide basis, doing things remotely or sharing counties. So that's a benefit, I think, of having a centralized pretrial agency that services every county. And then you don't have that where the big counties have all the money, right? So the more populated counties have bigger budgets, so they're going to get more than your small counties. And this way we're able to again, I guess it's all back to fairness for us, but but again, I've not worked, and I know some very well. I mean, there's great county pretrial programs out there across this country. I mean, they're wonderful, and I would think maybe the state might make them worse. I don't know, but since that's the way we were set up, I can see the benefits that way. But again, I've not worked in another system to be able to know if that's better or worse or the same. I don't know.
We have a question about the AR process. Who pushed back on that idea, and has the pushback kind of decreased after you've seen some of the outcomes?
Well, initially, the idea actually came from our judges. We have a judicial committee that our chief put together on pretrial. So the initial idea came from our judges. We did have some other judges that weren't part of the committee that had a little bit of pushback in the beginning. I don't know why, but so that was the first set of pushback. And then this recently, with the expansion to the felonies, we have had some of our prosecutors speak out that they're not fans of the program, and they give and some of the reasons are legitimate reasons. One is like some of our rocket dockets, where when people are in jail at jail arraignments, then they can put them in the rocket docket to expedite and get them into treatment faster. But sometimes that requires a plea. But if they're not in jail at arraignment, then that is delaying, I guess, the rocket docket. So I mean, that's kind of a legitimate one. So we're trying to work through ways that we can get people that are released onto that rocket docket, as opposed to having to be in custody. So that was another pushback. That was really, it's mainly a couple of our prosecutors and some of our judges. Some of our judges but didn't particularly like the program. But again, we share our data with everyone, with our legislators too. So yeah, I mean, I don't know if the pushbacks went away. It's not as significant as it was initially. The majority approve of the program, and our Supreme Court agrees, so we still have the rule.
Can you talk a little bit more about the risk assessment that you use and how you implemented that?
Yes, sure. I should have probably did that when I was talking earlier, but yeah, we currently use the PSA, which is the Arnold Ventures tool. We were the first ones to use that in 2013. So that's the tool that we use now. Prior to that, we had our own that we had validated using an outside entity, but we switched to the PSA in 2013, and we've been using that ever since. So I don't know if you want me to go into how that works, or are the people familiar with the PSA?
Maybe if you want to do just a very brief overview for anybody who hasn't heard of it.
Okay, basically it's a two-tiered risk assessment. It has two scales. It has an FTA scale and it has a NCA scale, which is new criminal activity scale. And all of the factors on that tool are all criminal history based, with the exception of age. So it's not a tool that requires a pretrial interview. I mean, we still do an interview, for one, because it's statutory that we do the interview, but two, because we need to get that contact information for that text reminder. So we have to talk to the defendants, but it's set up to where you don't necessarily have to do an interview to score it. And again, it's criminal history. It's factors such as prior convictions, prior misdemeanor, prior felony, prior violent crime convictions, FTA history, whether or not someone has a pending case, and then each factor is scored based on its predictability of what it's predicting, failure to appear or rearrest. And then we in Kentucky use the PSA. We use the raw scoring. The normal PSA takes the scores into like a 1.6, but we use the raw numbers. That just works better for us to use the raw numbers. So we take those numbers and we decided as a state how to label people low, moderate, high based on the score. So that's pretty much a really quick rundown of what the PSA is. But if you all go to the Arnold Ventures website, you can actually get the PSA, and it explains the factors and the points and everything.
And PSA stands for Public Safety Assessment. We had that question.
Yes. Sorry, I should have said that. Yes, you're correct.
Yeah, you use it so much though. I'm sure PSA is just something that you say now without even thinking about it. Let's see here. So I know that you do text messaging and phone calls. Are these automated or with a live person?
Our text notification is automated. We basically get the text number from the defendant, we enter it in our system, and then the computer takes over from there, and they get a text 48 hours or 2 days before their court date, and then 1 day before their court date. So they get two. The calls are by the staff, and the only people that we call are those that either don't authorize us to send them a text, or they don't have a capability to get a text. Then we'll make the manual phone calls for those. There's very few of those. Everybody pretty much has a text number, and if it's not theirs, they'll give us a number to their parent or their significant other or a friend or somebody, so that they can get that message to them. But yeah, the phone calls are manual, and that's one of the things that we saved a ton of money when we switched to the court notification text reminders, because we were using staff to make phone calls, and I mean, we couldn't even send it. We couldn't call everybody, because I mean, we have like 200,000 arrests a year. There's no way we could call all those people, so we could only call those that were under the pretrial monitored conditional release program, the supervision program. So now that we have the text, even though we have to pay for that, it's still less expensive than staff, and now we can send it to everybody, everyone that's released.
And you had mentioned a little bit earlier how important it is to collaborate with other stakeholders in the system. Can you tell us a little bit more about how pretrial has done that in Kentucky?
Yeah, it's very important. So early on, of course, the Supreme Court, of course, has their committees that they have judges and stuff. So we're always collaborating with our judges. But then about 10 years ago, we started reaching out. Well, gosh, it's been more than, it's been about 15 years now, with our Department of Public Advocacy, our Public Defenders Division. So now we've developed a way that we cross-train. So like I go and speak at their new lawyers training, and then they come to our new employees training. So we're constantly talking and collaborating with our public defenders. Now our prosecutors, again, we started attending their state conferences and just giving presentations or having like Q&A sessions just to talk about what we do. And on the anything that's going to be legislative, like if the legislators are going to change something or propose some type of bill, then we always get together, the courts, with the prosecutors, with the public defenders. Our Jailers Association has been involved in this, and we just communicate, and everybody gets to sort of have a seat at the table so that they can discuss. And it doesn't always mean that what each individual entity wants, they get. You know, we don't get everything we want, but at least they have a voice. And I think it makes, and you know, part of our administrative release, you know, we did talk to some of prosecutors and public defenders and jailers, just to get their input as we develop that program. So it's just really good to, I think, to collaborate with others, see the point and the place that they're coming from, and it can only make you better because we can't just be one-sided. So that's been very important to us to collaborate. And again, we don't always agree, and sometimes it's heated, but at the end of the day, you know, we all have a role, and everybody's important, and we just respect one another's opinions.
And when you say that you're, you know, inviting all of these groups to the table, have you ever invited any community organizations, any maybe outside of the typical pretrial realm? Maybe it's public health or victim services agencies?
Actually, yes, we have. I should have brought that up. Not on like everyday stuff. It's not like we have a standing committee, but yes, we do collaborate with them. We actually have I'm not sure if we got some grant that we're collaborating with the community health and behavioral health folks. So that's something new where we're going to try to build a process and like they're going to give us technical assistance on how to handle. So that's one. And yeah, as far as like the community members, our Supreme Court recently, well, it's not recently, everything seems recent. It's like we've been hoarded up for all these months, but actually it was last summer did a series of community sort of like town halls where they invited community members and we all got to speak. I mean, each department got to speak about what they were doing, and we got feedback from actually community members. So that was something that we had started last summer, our Supreme Court did. And then on some of the crime commission groups that we have also include community members, treatment providers, victims advocates. And again, back to what I said about the legislative groups, they always have victims advocates there. They have, even the Chamber of Commerce comes to those. I mean, so it's a whole big group of people that talk about whatever topic, whether it be bail, whether it be sentencing reform, all criminal justice issues.
That's great. And I think that is probably all that we have time for today. But we talked about so much. I was wondering if you had to just choose one piece of advice for our participants today, what would that be?
I think just stay true to your mission, you know, and justice. That's our one of our is pretrial justice. Stay true to that, and always make sure that we're treating people fairly. And everything that we implement, whether it be a policy or an agency or a practice, if you just keep that in the forefront of, you know, presumption of innocence, pretrial justice, equality.
Well, thank you so much for being here with us, Tara. A lot of great information. We really enjoyed having you.
No, it's my pleasure. I love it. I wish I could be like in person, but you know,
I know.
This is the world we live in.
Maybe soon, hopefully soon.
Yes, but no, thank you. And if anyone has any additional questions, I mean, Jessica has my contact information. Feel free, you can reach out to me directly. I'm happy to answer any questions that you have going forward.
Appreciate that. Thank you so much.
Thank you.
So now I'm going to turn it over to Gary, Program Manager at OCJP, to share a few more things before we wrap up today.
Thank you, Jessica. I hope everyone can hear me. Next Tuesday, September 29th, will be our third and final live webinar. I hope you can join us again to hear our panelists discuss the outcomes of their pretrial reform efforts. 2 Tennessee counties, Davidson and Knox, have been diligently working to improve their pretrial systems over the past several years with grant funding from OCJP. Panelists from both counties will join us to talk about the process, the results they've seen so far, and their plans for the pretrial systems moving forward. If you haven't registered for this webinar yet, you can still do that on the event website. The link should be posted on your screen in the questions tab. If you have an extra 30 minutes in the next couple of days, remember to check out our interviews with national pretrial experts, Judge Ronald Adrin, and NAPSA President-elect Spurgeon Kennedy. Judge Adrin and Mr. Kennedy have about 80 years of pretrial experience between them. And during their interviews, they offer their insight on pretrial best practices and straightforward steps to improve pretrial systems. A sneak peek of these interviews will now play in just a few seconds.
We now know more about risk today than we've ever known.
Pretrial reform, bail reform is a win-win situation.
Being able to identify the data that a judge needs to have in front of him or her when they make a decision is critical.
Everybody can be better because of the fact that there were changes made to the way that we have traditionally done business.
All right. Now that you guys are all motivated on the subject of pretrial, I encourage you to review the funding opportunities listed on our website here at OCJP for counties interested in improving their pretrial systems. Again, I believe that link is on the slide, and we will also post it in the questions tab. In closing, thanks again for joining us today, and we look forward to seeing you next time. Have a great day.